All right, we're gonna get started.
Not sure if the mic is actually picking up for amplification, but it maybe is for recording. I'm not sure. Well, you guys can presumably hear me. I'm David Hoffman from the law school, and I wanted to welcome you all today for our session on current developments in blockchain law and policy, which was a title that was sufficiently vague so that we could talk about anything while we still weren't sure we were going to talk
We
about.
can't hear you at all, so we have to get that.
You can't hear me at all?
No.
Yeah,
Yeah, there we go. Is yours not on?
I guess not. Is that better?
Yeah.
Okay, so we're still here talking about blockchain, and I'm Dave Hoffman. We're going to be talking today with two guests, so I'm very happy to welcome. Immediately to my left is Kevin Werbach from the Wharton School. He is an associate professor of legal studies and business ethics. In addition to his influential work on telecommunications and internet policy, he's a pioneer in the emerging field of gamification, and he has a pretty fun book, For the Win, How Game Thinking Can Revolutionize Your Business. He also has a forthcoming book. When's it coming out?
October.
On blockchain itself, and that name of that book is, I have it written down, Blockchain and the New Architecture of Trust, coming to a internet store near you, and I recommend it to you. He's really a thought leader in this field, and we're very excited to have his commentary with us today. To his left is Joshua Clayman, who is of counsel and co-chair of the Blockchain and Smart Contracts Group at Morrison Forrester. She is one of the, I think it's fair to say, best known blockchain and cryptocurrency lawyers in the entire world. In fact, she was recognized by Chambers and Partners as one of the top 12 blockchain and cryptocurrency lawyers globally. She is the chair of the very well-known Wall Street Blockchain Alliance Legal Working Group and is a member of the Global Word and RegTech think tank, which Kevin helps to helm. She actually attended law school at Temple, where I taught her some number of years ago, and so it's a real treat for me to get to see her today in this unbelievably accomplished state that she has achieved. I had no part in it, having taught her none of the important courses. Prior to law school, she was a corporate consultant for a global publicly traded organizational consulting and career transition firm, and a deputy chief of staff and director of special projects for a nationally recognized political watchdog group based in Washington, D.C. I was just talking to her for the last hour, so she just is basically every single day of the week, she is somewhere presenting to someone, and so we are really lucky to have her here today to share her thoughts with us. So how it's going to work is she's going to talk first for about 20 to 30 minutes, give us a sense of what she thinks is new and happening in the field that she is in fact in the business of creating. Then Kevin's going to offer some responsive thoughts, and I'm going to come last and say some random things that are probably not particularly useful, but maybe help provoke some discussion. That'll be about an hour all told, and then we'll have hopefully about 30 minutes of conversation where you guys can ask questions. I know we have a mix of people here who are both current JD law students, LLM students, and then also people from practice in the city. We're very excited to have hopefully a robust discussion in which we get questions from all over the place and lots of different areas. I've prepared them both to answer literally anything except for which ICO you should buy, which is probably they can't warrant one way or the other. So without further ado, Josh, take it away.
Thanks so much. And as was sort of said, I live and breathe this stuff now, so I could go on talking about this for literally hours and days until you guys all politely excuse yourself. But I'll try and contain things to a set of slides. I probably won't even cover everything in these slides. I want to hop through. There's a few things. If I just have a roadmap real quick. Hang on. I think I may need to stand back up. Oh, here we go. So I will stand up. So the roadmap is I want to go through some of the regulatory updates lately and also some backdrop. And then I think I'll finish up on the second half with talking about some of the practical implications and how these things actually affect actual agreements. So how you might actually sort of the rubber meet the road, as you might say. So let's move past this. All right. Now, I don't know how familiar everyone is with blockchain in general. I'll just give like a one very quick 30-second kind of background for those, just so we can level set a bit. And this is not a technical explanation. So those who are very technical will beg to differ with my explanation. Basically, if you imagine a global database running on millions of computers and you're all looking in at the same golden copy. So you don't have an entry on one database and then an entry in somebody else's database. You're all looking at the same exact entry. So this is said to create trust, where ordinarily you wouldn't have trust among people. And ordinarily you might need an intermediary, a trusted intermediary. For this, we can all see the same thing right in the center of the room so we know what's happening. No one's going to sneak in and change something because we're all watching. Now, if you step back for a moment and you think about the data, and you think about it in terms of blocks of data. So all this data in the database is in blocks of data. They're arranged in chronological order, and each successive block contains all of the information in each preceding block, okay? And it is encrypted, but the idea is that a bad actor can't really go back in time and change something secretly in a prior block because all of the data is already contained in the successive blocks. So these are some ideas behind blockchain. I won't go into smart contracts, although certainly I can just say they use if-then logic to cause the happening of one thing upon the happening of something else. That is another story for another day, and I'm happy to talk about that ad nauseum at a later point. But digital tokens, one use case of this blockchain smart contract coming together is as a store of value. Tokens can be used for a variety of purposes, to build networks, network effects, to use them as membership accesses, things like that. And lately they've been used for fundraising a lot. And I just would like to spend a moment to talk about what a digital token is. Now, there's a lot of controversy, which we'll get into, about whether these are securities, whether they're commodities, what are they? But at the end of the day, what's important to remember is they don't really have characteristics of their own. All they are is a string of numbers on a digital distributed ledger. So don't think of coins or tokens, if you will, not the Chuck E. Cheese tokens or something like that, or video game arcade tokens. Think of your credit card number. Think about what, if you have a database full of credit card numbers, what you can do with those numbers. And then you can start seeing why it may not really make that much sense, even though it is the prevailing regulatory view in the US, to say that every single token in and of itself is a security, right? Because you can see when you come home with Microsoft Office, what is the first thing you do when you put it in? At least as I recall, it says, please put in your license number, right? So you enter that. Well, so you can start seeing why a string of numbers might represent a license to use some sort of software. You can also see, if I said, everybody who purchases one of these strings of numbers, you're going to get $5 from me. That's one way you could structure it. You could also say, everyone who has one of these strings of numbers will get a vote in this ecosystem. You could say that I'm going to allow access to my ecosystem, and the one with the lowest number is going to be first in line. So when you start thinking about it this way, and you start thinking about how you structure it, you can see why some very well may be securities. They may look very much like traditional equity or debt securities if you structure them that way. But they also may look different. Now, stepping aside from the tokens themselves, these token sales, many of the token sales are sales of securities. In fact, right now, the prevailing view that has been expressed by certain regulators, some prominent regulators such as the head of the SEC, is that all of the ones that he has seen thus far have the hallmarks of being a security. But as we'll kind of go through, we can talk about what some of the regulatory requirements that apply to that and the considerations. But it's important to think about the tokens and realize that they can be a lot of things, whereas the sale process very often, not always in my view, but very often is a sale of securities. Okay, I should also say at this point, nothing I say is on behalf of my firm. This is all just me talking. And nothing is legal advice, nothing is investment advice. And yeah, so with that, the digital tokens and cryptocurrencies. So I have up here a grid that looks nothing like where we currently are, but this is Bitcoin and Ether, and you know there's a lot of volatility. I will say this because there's a lot of questions that I get about what is a cryptocurrency. Well, there is no real definition. Okay, all of the cryptocurrencies are digital tokens. Digital tokens is the generic term. So Bitcoin is a digital token. If you think Ether is a cryptocurrency, it's also a digital token. But not every digital token is a cryptocurrency. So cryptocurrencies are typically ones that we think of in terms of payments. Okay. All right, so quickly, a background and landscape. I won't go through all of this, but what I want to show here is that in 2016, there was approximately 256 million raised via token sales. And if you hold aside the DAO, which some of you may be familiar with now, but all of you will be familiar with soon when I go through the slide, you'll know that the DAO raised an enormous amount of money at the time. It was 150 million in digital currency, digital tokens. It raised it in 2016, and its marketing efforts were better than its smart contract. So immediately after taking in this money, about 50 million in digital currency was taken out by a bad actor who noticed some vulnerability in the smart contract code. And so if you hold aside the DAO, which ultimately gave back all of its money that it took in because, as some of you may know, it led to the hard fork in Ethereum, which is why we now have what we call Ethereum, and there still is, in a parallel universe, Ethereum Classic, which still has the bad transactions on it. Let me just take a pause for a moment to talk about a hard fork. So as I mentioned before, here, let me move to the side so other people can see me. As I mentioned before, you can't go back in time and change a preceding block. What they did, what they do if you do a hard fork frequently, and what they did in the case of Ethereum after the DAO, was they took an older block and they made a copy of it and they stuck it on the end, like an append-only database. And so that erased the bad act on what we now call Ethereum. But on Ethereum Classic, that bad action lives on. And this will become relevant later on, but when you subtract out the DAO, you get about 96.4 million that was raised in 2016. Now in 2017, and it's hard to find information on the web that actually goes through the end of the year, but ultimately by the end of the year, about 4 billion was raised. And it dwarfed the amount of VC investment in the same types of companies. Not the amount of VC investment globally in anything, but in blockchain-based companies. And that was true as of roughly the middle of the year. So some stats are up here. I won't run through every one. Now the next slide is a little bit not the best, because for technological reasons, I can get to it. This is supposed to be a comparison, so I'm going to say what it shows you. If you look at the top 10, and remember, subtracting out the DAO, you get to about 96 million, 96.5 million. Now, if you look at the top 10 of 2017, all of the token sales in 2016 come up to less than the number 6 token sale, which is KinKick. So that's just an interesting data point showing the growth. Okay, so rough comparison of traditional VCs versus certain token sales, certain digital token sales. All right, this is where I go into Shark Tank mode, okay? And I'm gonna fly through it in case any of you have heard it before. But the way I think about this, for those who aren't familiar, and I'm just gonna hold aside all of the kind of projects where, you know, arguably it's a protocol with a native token and it's not for investment purposes, it's really building out something for developers. I'm just gonna look at it from the point of view of a founder who wants to raise money. Okay, and that's what I'm going to do for the rest of this whole slide deck. So just hold aside all those edge cases that we're not going to talk about right now. If I'm a founder, okay, I go on Shark Tank. I'm going to say I'm going to make a deal. Okay, I'm very excited. I've got a deal going. Well, say I sell you my equity for a certain percentage of equity for a certain amount. Well, after you go off stage, there's going to be a lot of negotiations, right? You're going to be giving up rights. There's going to be veto rights. There's going to be all kinds of negotiations. But what if you didn't have to? What if you could sell something and you wouldn't have to give up equity unless you wanted to? You wouldn't have to be diluted unless you wanted to. You wouldn't have to give up control unless you wanted to. You wouldn't have to negotiate with the powerful VCs because you're going to offer them a sort of take it or leave it, automatically executing smart contract with certain terms that they can take or leave. And what if you could expand it so it wasn't just the VCs? What if you could say, hey, my grandma wants to invest, and she wants to put some money into this. And what if you didn't have to exchange signature pages? All of it's automated. Well, then you start thinking about tokens. And again, as I kind of alluded to earlier, you can make the token whatever you want, basically. You can structure it to have whatever characteristics you would like, generally. That's different from when you're selling equity or you're incurring debt. Those are things that there may be some flavors in between, what different shades of preferred stock look like, but we basically know what that is. Whereas with token sales, it's a wide open field. So a deeper dive. Now, let me just take a look here. There's no Platonic ideal of a token. This is what I've already been talking about. I won't belabor this. And let's see. Tokens typically are sold in exchange either for fiat currency or for digital currency. And tokens may have some non-incidental utility. Okay, you've probably all heard of utility tokens. But it's important to remember, no matter how much or how little time we spend on this, a token that has utility still may be a security under US federal securities laws. So bear that in mind. Just because someone says, I have a utility token, it doesn't mean that they're not still selling securities. Okay. Also, there's no bright line test that determines when a token would not be a security. Although some would argue that right now, with the rhetoric in the market, there is a bright line test, and that's that every token is a security, right? So, and that certainly is a view that many law firms are taking right now, a conservative view, that if you can't get some sort of guidance from the SEC directly as to a particular deal, that if you're selling in the US, if you're selling tokens, you need to treat them like sales of securities. Okay. So I'm just going to go over a few things real quick. If you hear me saying ICO or token sale or token generation event, which I probably won't say because it's a lot of words, it's all the same thing. Okay, if I talk about a pre-sale, it's the same as a pre-order. If I talk about a token that's a security or an app token, sorry, utility token or an app token, got distracted. That's something trying to say it's not a security. Okay, so skipping through here, a few things, a few pretty important regulatory matters. So one, the Dow report last summer, it basically looked at the Dow, which was a virtual venture fund. It was pretty much the paradigmatic token that is a security. And it said this was a sale of securities. It said, basically, no matter where in the world you launch your token sale from, if you're selling to US persons, you still need to worry about US federal securities laws. And the Dow was a virtual venture fund. Okay, so it wasn't even an edge case. Some other things they said was that the Howey test applies. That is a multi-pronged test. It looks at, was there an investment of money in a common enterprise with a reasonable expectation of profit based solely or primarily on the managerial or entrepreneurial efforts of others. That's a mouthful. But basically, that put everyone on notice that some of these may be securities. But they didn't say which ones weren't. So people were struggling in the market saying, how do we figure this out? And so this idea emerged that, oh, well, some of these have utility, so we're not maybe these aren't securities. And then we got the case of Munchie. So in between the Dow and Munchie, the SEC developed a cyber unit, and they basically started cracking down on outright frauds. Other things were going on in other countries, other regulatory treatment. But what Munchie said, Munchie was the first case, it was a cease and desist order, where they stopped a token sale midway through, and there was no allegation of fraud. It was the first time. So Munchie was a California corporation. They created an app that was going to rank restaurant meals. And the SEC said, great that you say you're a utility, and great that you said that some lawyer did the Howey test and thought that you weren't one. But guess what? You're selling securities. And that's because the manner of sale matters, and it matters a lot. So some of the cases interpreting the Howey test, which originally was a case involving orange groves for over 70 years ago, they focused on how the various things were sold and said, okay, this made it an investment contract. So when the SEC looked at Munchie, it looked at the white paper, and it said, oh wow, there's a flow chart, and it shows that as network adoption increases, the value of the token is going to increase, which is probably true. But the fact that it was put there in a in an actual visual, this was said to suggest that people might have a reasonable expectation of profit. Okay, because when you look at different things, like if I'm buying Ether on Coinbase, okay, I'm not buying it to have it be gas to run something on Ethereum. I'm not. I'm buying it because I think it might go up in value. And so you can't look at what every individual person's doing. You kind of have to look at the idea of what the issuer is doing. And so that's what this gets at. Now, some other things about Munchie that are notable, they also looked at the fact that the token seller, it had said this is only for US, yet they were selling it all over the place. They also, they had not been marketed to people who were interested in investing or interested in restaurant meals. They were marketed to people who were interested in investing in tokens. They also had said, we're going to make sure that there's a secondary market so that we're going to have this on exchanges. And interestingly, because I didn't know that the SEC was this cool, no offense to the SEC, but they actually had gone online on social media and found a YouTube video where somebody had been saying, and this is going to go up in value. And it wasn't even someone associated with Munchie, but Munchie had somehow linked or liked on Facebook that YouTube video. So all this led the SEC to say, yep, it's a sale of securities, you have to give back all the money. And they also said this thing, which I think of as dicta when I think back to law school. They didn't have to say this because the token sale for Munchie, it was not a functional token, whatever you may want to say functional means. They added this language that says, even if the Mun token had been fully functional at the moment of sale, it still may have been a security. And some people say that that may go towards some of the strategies that people have used in the market, where they said, we're actually going to call this a security until the moment when it's fully functional. We won't get into that too much right now. I'm going to hop through this. Okay, so the SAFT, which is actually that. The SAFT I won't go into too much, but it is a simple agreement for future tokens. There also are things called SAFTs or safeties, where it's for tokens or equity, and it's based off of a SAFE, a simple agreement for future equity. The SEC has never said that using a SAFT can permit pre-sold tokens to not be considered securities at the end of the day, although that has been something that has been in the market, and one of my colleagues and friends at a different firm put forth a white paper about that, which was a proposal. And I will say, in the current market, I'm not comfortable using a SAFT with the expectation that it would end up in a token that is not a security. Certainly you could use a SAFT as a pre-sale if you say that the token will be a security at the end of the day. But the idea behind this is the rationale had been that, when you're pre-selling a token, you can't use it yet, then you're clearly selling a security, and the purchaser is bearing enterprise risk, and that it's somehow different when at the end of the day you have a token that's sold and it's fully functional, whatever that may mean. That's another gray area. And that at that point, the investor bears product risk. So I could talk about this all day. I have pretty strong views about the SAFT. I co-wrote a paper about it called Not So Fast with the Cardozo blockchain project. But my concern in general with it, again, this is my personal view, and it is not, it's just a concern, is that sometimes in some of the SAFTs, because there's no one form that is accepted, in some, people are explicitly purchasing only for investment and not for use. To me, at the end of the day, when you look at a resulting token and you look back to see the manner of sale for that token, if you end up with a material portion of tokens, or often an extreme majority of the tokens that are being sold to people who have no intent to use it and are buying it for investment, to my mind, that makes it harder to say that it wasn't a security. Okay, so ATSs. All right, alternative trading systems. The other thing about the DAO that people don't focus on, they often focus on, is it a security, is it not a security with the token? The other thing the DAO guidance said was, the platform on which the token was traded, it is a securities exchange, and it should have qualified as a national securities exchange or as an alternative trading system, broker-dealer, avail itself of an exemption. So that's why if you go on exchanges that serve US persons, there's an intentionally small selection, which can be really frustrating if you're trying to buy some of the cooler other tokens. But it is because those platforms, whether right or wrong, made some sort of determination as to what kinds of tokens were securities and that could go on their platform. Of course, the SEC put out a reminder more recently about that, and we think that that the actual exchanges are likely to either qualify as ATSs or somehow affiliate with broker-dealers, or get rid of some of the tokens that are on the platforms. So subpoenas, that's written down there. You may have heard that in the market there have been subpoenas that have gone out to various players in the space. I would like to just put this out there. I think a lot of people are concerned about what this means and whether this is going to lead to dozens and dozens of enforcement actions. But I think it's important just to put things in perspective, which is that subpoenas are the SEC's way of finding out information. So some of this may be fact-finding and likely is. And certainly, I think the regulators are trying to strike a balance, in my view, between protecting retail investors and not trying to completely foreclose technological innovation. So I'm going to hop through here. This is just showing there are many other other legal frameworks, even just in the US, that are relevant. So I always say that working on a token sale is a team sport, okay? You need all kinds of expertise. So the FinCEN letter to Senator Wyden from February. This, some of my colleagues have been quick to point out, this does not have the force of law, but this is another super important area that we're gonna have to explore, and it relates to money transmitter and related laws, Bank Secrecy Act, Financial Services Regulatory, and whether the platforms, and in fact the issuers themselves, many of them may need to register as money transmitters or otherwise register. And this gets into KYC, know your customer, anti-money laundering, really important things. I wish we had time to go through it in greater detail, but this is as important as the security stuff. It's not just a one-size-fits-all analysis. There's lots of stuff to worry about. Also, some of the things here, I won't go through everything, but there are federal criminal statutes that apply, and willful blindness of having folks who may be purchasing for, with proceeds of crime and other sorts of things. That's definitely not okay. So non-US jurisdictions, I won't go through this too much except to say that other jurisdictions have spoken out. Some want to be destinations, such as Gibraltar. Certainly places, also Isle of Man, Cayman Islands. Switzerland has spoken out and recently gave really interesting, and I think very good guidance. FINMA spoke out and described 3 types of tokens, including payment tokens and asset tokens. Basically so that you can have classifications that may not be securities and utility. Other jurisdictions such as China or South Korea have actually banned token sales. It appears that they're going on anyway, and that it's difficult to put a damper on some things, but at least as a legislative matter, they're not allowed to do it. So it's really interesting to see how this unfold. There's also been guidance by Singapore, which is another place where people frequently do these. I will say, I'm going to go into the practical considerations real quick. I want to say some trends, though, that I'm seeing just from practicing. Right now, a lot of the big projects, either they are starting to say, I really do have a token that's a utility. I'm a developer, and this, not me personally, but the clients, and this really is a protocol with a native token, etc. It's open blockchain, open source, and they're actually avoiding the US. I never thought we would get to that point, even though people said we're gonna end up having the US being excluded, but I'm seeing it. I'm seeing people say we're not gonna sell into the US for the pre-sale or the sale unless we speak with the SEC or have our lawyers speak on our behalf and get some kind of comfort. So that's one thing I'm seeing, and that's for tokens where the very making of them of securities makes them unusable, right, or unworkable. The other things I'm seeing is that a lot of people are embracing the idea of security tokens in the US. And so we're seeing a lot of deals where they're either doing marketing, issuing, and selling to US accredited investors, so people who have a certain net worth or a certain income, it's a defined term under the securities laws, under Reg D and also to non-US persons under Reg S. A lot of those Reg D offerings to US accredited investors are being done under 506C, which is one of the Jobs Act liberalizations. There are certain requirements about that, but basically the good thing is you can do general solicitation, general advertising. Other people are considering Reg A+, and that is basically a mini IPO. So there's some interaction with the SEC, there's some disclosure. Some people are considering marrying the Reg D followed by a Reg A+, which allows you, under Reg D, you have certain transfer restriction requirements. And if you follow that with a Reg A+, you can at least take part of the, I think it's up to 30% of the tokens that you do in the Reg A+ can be registering the resale of tokens you did under Reg D. So that way it sort of unlocks them for trade. I think as we see more, and we also have some that are considering doing things on an S1, almost like an IPO for tokens. We also have some people who are considering equity offerings and then potentially dividending tokens. So there's a lot of different creative things that are being considered. Now, one thing that I think will help fuel this movement towards security tokens is that now we're starting to see ATSs that are popping up. Templum has launched, although nothing's on it yet. T0 is in the works, and many others. So I think as we start having opportunities for liquidity for those tokens, there'll be less of a reason to try and say that they're not securities. Because right now, if you wanted them on an exchange, you would have to say it wasn't a security. So a couple more things. In Wyoming, there was great legislation, well, I should say there was legislation passed. I'm a big fan of Caitlin Long, who's part of our Wharton RegTech and a good friend of Professor Rohrbach's, who pushed along 5 bills about blockchain, one of which is House Bill 70, which all of these were signed into law. And House Bill 70 was based in part on the FINMA guidance. And it says that in Wyoming, there are such things as tokens that are utility tokens. And it'll be really interesting to see how that plays out and whether, Wyoming, who knew? But then again, unbeknownst to me, Wyoming was the birthplace of the LLC. It has really great privacy laws for entities. And who knew also the richest county in the US, I believe, Teton County, is in Wyoming. So it'll be interesting to see what the federal government does with that and whether they might use that as a model or whether that might just be something within Wyoming. But basically, Wyoming has taken the view that the token is a new form of property. Okay, so selected practical considerations. Okay, I'm gonna skip over this to a few other things. So if you think about, okay, so before I was into blockchain and crypto, I was a leveraged finance lawyer and a corporate lawyer. So a lot of things, I never was quite as excited about credit agreements and convertible notes as I am about blockchain and things like that. But when you actually start looking in the real world at how these token sales interact with existing documents, it's really interesting. And I don't think a lot of people have had the time yet to work through them. But I'll put a few things out there. So for example, for those who might be interested in venture capital, right? Or who may have investors with existing SAFTs or warrants, convertible notes, things of that nature. A lot of people just think, oh, well, if there's this massive liquidity event, right, called a token sale, and someone's bringing in all this money, well, that's going to be a liquidity trigger, but frequently it's not. Frequently it is not. And so I think we're going to have a lot of amendments to different agreements to say either that investors want to have a veto right or a consent right to the company doing a token sale, or else perhaps to amend the definition to say that doing a token sale is going to be a liquidity trigger that will permit conversion, or I guess that doing a token sale, the investor will be able to participate and receive tokens. So I think that'll be an interesting space. I also think, and I'm going to get to credit agreements in a moment, which I'm going to make sound much more interesting than they sometimes are. But before I do that, I'll say this. What also is interesting is this idea that some people are saying that the purchase of tokens is a pre-purchase of goods or services. So what does that mean for a company if it were to go bankrupt? Okay, I'm not a bankruptcy lawyer, let me just put that out there. But right now, these companies, many of them are flush with cash. But if you end up having these people who have pre-purchased goods or services, and it's in bankruptcy, do they end up ahead of the creditors, the secured creditors? Well, maybe they do, and I think that's something we really need to think about, and it would be a really interesting thing for an article to think about that. I don't think I've seen anyone do that. Now, some other things about token sales. All right, if you think about commitment papers, which for those who may not have lived and breathed commitment papers, I'll say they're basically at the outset of a deal. It could be if you're doing, an M&A transaction or a credit financing, you enter into these documents called commitment papers. And often there are certain concepts in them, like you'll say, I want to have exclusivity. And so usually there will be provisions that relate to that. And typically they say, well, you can't do an equity or a debt or a hybrid equity and debt transaction. They typically do not say, or a sale of digital tokens or something like that. But I think they need to, and I'm certainly starting to mark documents to include that. I'm going to be working with the LSTA to update forms of credit agreements and also to propose some language for commitment papers to address this stuff. And so some other things, alternative transaction fees. Well, you have to look at your definition of alternative transaction. It can't just be debt and equity anymore, right? Because there are these whole other ways that people can just drive trucks through the hole in the form of digital tokens. So then if we think about credit agreements and many other types of agreements, you start thinking, well, what is a token sale? Is it a sale of equity? Is it an issuance of debt? Is it really prohibited under your credit agreement if you have a credit agreement? Do you have to prepay the amount you receive, right? Usually you have a mandatory prepayment for debt issuance, for equity issuance, for asset sales, but often asset sales has a reinvestment rate. Is this an asset sale? And do you get to reinvest the money? Or do you have to pay it back to the creditor? Also, some people will say, well, it'll be saved by the excess cash flow. Well, I think that's a question for accountants. If you receive payments for your tokens, and those are in digital currency, Bitcoin and Ether, for example, is that cash? Is that cash for purposes of excess cash flow? Is it cash for purposes of your financial covenants? And how do you calculate this? For EBITDA, for example, do you count this towards EBITDA, right? And when do you measure it? How are you going to value how much you have? Is it just the end of the quarter you figure out how much everything's worth? How do you reconcile this? So there's all these real world questions, even things like change of control or fundamental change. Or you might say, well, this isn't a change of control. The same company is still owned by the same people. But really, you can have tokens that have voting rights. And if you do this out of a Delaware Public Benefit Corporation, for example, they could have, there could be instances across entity forms where you might have a consent right in favor of certain token holders. And how does that work when you're granting a security interest, right? Do you need the consent of the token holders in some cases? What does the lender need to know? There's so many things like this. I know we're not bankers here, but if you put on your banker hat and you think about this, you can also think for both investors and bankers, you might invest in a company, and then if it does a token sale, if it doesn't do it right, it's a much riskier company, right? So if it doesn't do the KYC AML right, and it's got all these criminal challenges and regulatory challenges, how can it comply with its compliance with law? And also, many other things like that. If you do this, and one thing that DAO guidance did not address, because the DAO was no longer in existence, they added a footnote saying, we're not even going to consider yet here whether this was an investment company. But what if, because it didn't exist anymore, what if it became an investment company? Does this blow your 40 Act rep, which is really needed for a lot of different kinds of transactions, including credit agreements? So this is just a little a teaser, probably not as interesting to you as it might be to me. But anyway, these are all things we need to think about, and I guess I'll wrap up with that. So.
So thank you. That was fantastic, and I'm going to try to be brief because Josh covered so much ground, and I want to have time for your questions But I think Josh's presentation was really excellent in that you hear a lot in the cryptocurrency space, people saying blockchain supersedes law. Its code is going to blow away law. We won't need any lawyers. So any of you that are here in law school who might have thought blockchain is going to cost me my job, no. Blockchain is going to get you your job. If you heard all of that, you didn't think there's a tremendous need for people with good legal expertise, including legal expertise in traditional established areas like securities and corporate law, to work through all these hard issues. That's clearly what's needed, and there's just not enough people who understand these things and who are sensitive to the technology, people like Josh, who can actually help clients navigate these waters. And it's not going away. This is something that's really coming to a head now, but it's clearly going to be with us for a long time. So let me see a few general things and some speculations about where we are, and then turn it over to David. So on one hand, this looks like a mess, and Josh sort of went through this quickly, but just to put it clearly, so the SEC has said that most, if not all, ICO tokens are securities. Interestingly enough, in the Dow report, though, they suggested that Ethereum is not a security. They didn't say, well, the Dow was a security and also Ether, the Ethereum token, should have been subject to securities laws, even though Ethereum did an ICO. It wasn't called that at the time. It was early on. It was in 2015, 2014. But basically, it's what we would now call an ICO. The basic assumption was that at the time, people were buying Ether to promote the platform and to get the gas, to get the fuel that you need to run these applications and smart contracts. Now, it's true that you can now buy and sell Ether and trade it on an exchange, but even there, the SEC was willing to say that Ether and presumably also Bitcoin are something more akin to currencies and they're not securities. But at least in the first instance, it's clear that some of these things in the view of the SEC are securities. The CFTC, the Commodity Futures Trading Commission, which oversees derivatives and commodities, has said cryptocurrency tokens, in our view, are commodities. So we can regulate them if you want to offer some sort of derivatives transactions, some futures or options, hedging strategies with cryptocurrency tokens. They're under the jurisdiction of the CFTC as commodities. The IRS, back in 2015, said that cryptocurrencies are property. Because the question was, what happens if you buy Bitcoin at 300 and then you sell it at 1,500 or 15,000? How's it taxed? They said, well, it's not like buying a currency. They said it's like buying a commodity, a property under the tax laws. FinCEN, which is the agency within the Treasury Department that handles money laundering, and also Department of Justice in a number of cases prosecuting money laundering, has said cryptocurrency tokens, including things like Bitcoin, they are money. So they're subject to some of these money laundering laws. For example, Josh mentioned the recent letter to Senator Wyden suggesting that these are money services businesses, even potentially just offering a token might expose you to all the requirements of a money service business, these onerous know your customer regulations and so forth. So those are 4 different categories. On top of that, the Federal Trade Commission has stated, we think we can regulate cryptocurrency transactions too, because we have broad jurisdiction over consumer protection, over unfair and deceptive acts and practices. And if you engage in fraud in selling your ICO tokens, we don't care if it's a security or not, it's fraud, it's deception, we're going to prosecute it. And so the FTC just recently set up a working group and announced some enforcement actions here. So that's at least 5 different classifications in the US. And Josh and David mentioned a couple times, there's this group that I run that's an invitation-only experts working group among regulators and private experts around the world on cryptocurrencies. We had our last meeting a couple weeks ago, and we were going through this, and one of the regulators from a European country said, oh my God, you have a lot of sheriffs in the US, don't you? And it's true. We've got all these different regulators in all these different categories. And one thought is, well, this sounds like a terrible problem. How can something be a security and also a commodity and also property and so forth? It's not so bad. So each of these regulators is looking at this within their own lens. So the SEC is trying to say, well, are you required to register under the securities laws if you offer this cryptocurrency token in an ICO? That's a totally separate question, potentially, from are you subject to these anti-money laundering, know your customer rules for certain sets of transactions? Or if you're offering some sort of derivatives trading, are you under the CFTC? It's entirely possible the same token can be subject to multiple of these different rules in different circumstances. There are, however, lots of edge cases and lots of gaps, and that's, in terms of current developments, what we're working through now. So for example, the CFTC has jurisdiction over market manipulation for commodities. So if you're doing something manipulative to pump up the price of some options or some futures you're trading, CFTC can go after you. It's not so clear they can go after market manipulation on the spot market. So what happens if there's trading in Bitcoin, but it's not for some derivative, it's trading for the underlying asset, and they have evidence of market manipulation, there's just a jurisdictional question there. So there are a bunch of these questions. The FinCEN letter is another one that raise these kind of edge cases. And it's not such a bad thing to have lots of different regulators, but we're in the process now of working this through. The challenge is that the same thing can be for multiple different purposes. So when you think about an ICO, it can be at least three different things. One is what Josh described. It's a new kind of transaction to facilitate an application. It can be something like a license and API key. It can be a way to kickstart a business. So if you want to get to scale with a new kind of social business, how do you compete against incumbents when you've got no network effects to start? The idea of selling tokens can be a way of monetizing that. It can create economic incentives for these new kinds of open platforms as opposed to one private entity controlling all the power in the platform. That's something new and different. Another thing an ICO can be is pure regulatory arbitrage. So if what you're doing is saying, I could offer this as a securities offering, but I'd be subject to SEC rules, I'd have to do an S1 or go under one of these exemptions, only offer to accredited investors, for example. But I want to do the exact same thing and just not have any of those requirements. Gee, that would be really nice if I could just wish away legal obligations that apply to everyone else I'm competing against. If that's what you're doing, there's no good argument to say you can just arbitrage away the law by saying it's blockchain, it's different. So that's a second thing that clearly is happening. That's part of what's motivating some of these SEC comments saying a lot of these are securities. You shouldn't be offering them saying because it's blockchainy and different and it's an ICO or it's a token generation event, you can get out from under the rules. The third thing that's happening is fraud. If there are not the disclosure and anti-fraud requirements and filing requirements of traditional securities law, and if it's an environment where these can be offered to anyone around the world, uneducated investors, in this frothy market where people are seeing massive run-ups in the price of cryptocurrencies, and people are willing to send money in this fairly anonymous way to anyone around the world that puts up a YouTube video and a white paper, it's a recipe for fraud. And there clearly is a tremendous amount of fraud going on. And it's hard to just say, well, it's the regulator's fault. You should have stopped the fraud. If the argument is we should get rid of all of the mechanisms that exist in traditional securities regulation to prevent and oversee that kind of fraud. The challenge is all three of those things are happening. And they're happening at the same time, and it's hard to sort them out. And so that's what regulators are doing right now is they're trying to go through and sort them out. And as Josh said, this is happening in the US, and it's happening in other countries. And basically, from my perspective, what happened was the US regulators, I think appropriately, initially decided to err on the side of caution. They said, we don't want to chill innovation. Something is clearly happening here that's new, that's cool, that's a great way of creating new opportunities for companies, that's leveraging this new technology. The last thing we want to do is regulate too early, is jump in and say, not welcome here in the US, stop the innovation, push it all overseas. So they tried to say, look, we're not eliminating any regulation here, we're just saying we're going to look at it carefully. The problem was the market took that, things like the SAFT, which seemed to legitimize these transactions without having to go through securities regulation for the transactions around the tokens. The market took that as just a starting gun, to just, okay, the regulators have said you can do it, and so it just created this explosion of activity, again, some of which was legitimate, some of which clearly wasn't. So what's happening now is the regulators are trying to put the genie back in the bottle. And again, I think they're doing this as well as they can, but they're now trying to say increasingly strongly, look, don't think we are not going to come after you. That's one of the things from the Munchie case. Don't think because it's a utility that you are not going to be responsible. Don't think we are not going to enforce here. The challenge is they have limited enforcement resources. These cases take time. So, for example, we just saw, not an ICO case, we just saw the securities fraud case about the Theranos $700 million massive blatant securities fraud in a Wall Street Journal article several years ago. It took all that time just to bring that case. The SEC is looking at potentially dozens and dozens of these cases. And Josh is absolutely right. Does not mean there's going to be enforcement action against all of them. Doesn't mean even when there is enforcement action, there's going to be criminal prosecution or even fines. But this is a process that they're going through as the market is still moving forward. So that's really the challenge that they face. Clearly, as Josh suggested, we're moving more into a world where these things will be regulated. The exchanges will be regulated. And regulators are trying to encourage that. There was a fascinating transaction about a month ago involving a company called Circle, which is a kind of diversified cryptocurrency company, not very well known, but very well funded, and actually very significant in terms of their scale. They bought Poloniex, which is probably the second biggest US crypto exchange after Coinbase. Excuse me? Oh, you worked on it, great. So maybe you can tell us more. But basically, the suggestion, at least the way it got reported, was that Circle acquiring Poloniex was a way to provide them funding and management skill to basically go through the process they needed to become a regulated ATS and to meet these requirements, and so that they could legally trade different kinds of tokens. And so we'll see if that happens. And the suggestion was the SEC might give some leeway about prior actions if essentially the company says, look, we're going to do our best to go legit and go through all of these steps. So that seems to be a direction that the regulators would like to see these companies take. But the question is what you do in the middle, because clearly there has been a lot of activity. Billions of dollars have been raised, and a big chunk of it, probably if we go back now, was not compliant with regulations that they should comply with. So last couple things I'll say, and then turn it over to David. Again, this is it's a global phenomenon. It's also a multi-jurisdictional phenomenon in the US. So you heard about the Wyoming legislation, but above and beyond ICOs, there is legislation about cryptocurrencies in probably about a dozen states, Nevada, Illinois, Delaware, Arizona, Vermont, about all sorts of different things, about whether you can use a blockchain for evidence in court, about whether you can have an enforceable smart contract, about whether you can issue shares on a blockchain as opposed to through traditional share ledger systems, that's the Delaware law. All of these have different definitions about what a blockchain is, what a cryptocurrency is, what a smart contract is. Many of the definitions, you read them, make no sense at all. So this is going to be a huge challenge, a bigger challenge when we think internationally. There's competition among different jurisdictions, but the jurisdictions are also looking to each other. One of the big takeaways from this workshop that we have at Wharton, we're bringing in regulators from around the world. They're extremely eager to hear from each other, to compare notes, and to hear from the private sector in a constructive way, what are the issues and how can we work through this? It's all happening in real time. So last thing I'll say, there's also all kinds of interesting new innovations and ideas coming out here. So my favorite one recently, Vitalik Buterin, who's the founder of Ethereum, put out this idea a month or two ago about what he called a DICO. So you may have heard of a DAO, a decentralized autonomous organization. Basically a set of smart contracts, a set of software on a blockchain that runs a company, does all the transactions in a company in an automated, decentralized way. He said, well, why don't we do an ICO that way? Let's set up an ICO, create a set of smart contracts that manage the issuance of the tokens, that ensure that the developers actually build the thing they're going to build. So it's one challenge with an ICO. How do you know they're actually going to not just run away with the money? So give them lockups, investing schedules, ensure that when they build according to the milestones, that then they get tokens released at that point. He said, well, we should do this in a decentralized way. And so that sounded really cool. And I said, well, this is great. I think that the insurance company Geico should issue a DICO. And they should use it to issue FICO scores or credit ratings. That would be psycho. So that's where we are. So thanks very much. I'll stop there to have David talk and have your questions.
I'm not going to say very much. I sort of wanted to make 2 points and then open the. I know you guys have been sitting for a long time. I want you to get a chance to jump in with questions. I think that I'm certainly, it's the case, I'm the least enthusiastic about every single part of this, except for the part where students get jobs in the room. And so I saw a statistic that horrified me recently, and the statistic, which I don't believe. So I guess I'd start with saying $4 billion doesn't seem like actually a lot of money. So, $4 billion raised in a market, in a multi-trillion-dollar financial market, seemed to me like something I don't really have to worry that much about. I mean, it's sort of interesting. It's interesting as a phenomenon. It's potentially revelatory about the future, and maybe it's going to grow very fast, and it creates some very interesting accounting and law questions that I think are deep and fascinating, but not the kind of thing that we need to sort of have a 5-alarm fire about. And then I saw a different statistic, which was that 8% of the US population reports owning or investing in an ICO, and if that's right within an order of magnitude, it's terrifying. So I thought, well, probably it's not right within an order of magnitude. But let's just say that 1% of the US population has been exposed to information about this, which strikes me as plausible because my relatively elderly, although very vital mom, asked me recently whether she should be investing in ICOs, and I thought to myself, that's a bad sign for the country, like a very, very, very bad sign. So I do have a concern, and the concern is not merely that it's difficult to tell what percentage of this is froth and what percentage is fraud and what percentage is real legitimate underlying activity. And the concern is that retail investors are increasingly becoming intrigued by the possibility of not having to work anymore. And one always hears stories. Your Uber driver, starts asking you questions like, "Oh, do you invest in ICOs?" And you're like, "Oh my God, everyone's in trouble." So I do think one thing to sort of think about here, and the reason why regulatory authorities are suddenly, I think, getting much more excited is because constituents are losing money, the constituents of the regulatory authorities. And so I think one has to sort of think a lot about what is the ideal ICO investor and what are they up to. So that's one statistic that worried me. The second thing I think relates to Kevin's last point, which is one of the interesting things that I think about this space is the distance between the underlying technology, blockchain, which is a trustless distributed governance system, a system that doesn't rely upon legal rules to work, and the governance of the ICOs themselves. And as some of you in the room know, we here at the law school, I have been organizing sort of a team of folks who've been looking at white papers of various different ICOs. It's an amazing team. There's always room for more. And those white papers are making all kinds of promises about what they're going to do with the money they've taken from the investors that they've raised from the investors in the underlying firms. And those promises do not seem to me to be in any way enforceable, in that they are not contracts, they are not instantiated in smart contracts, they're not instantiated in the tokens, so far as we can tell, although we're still working on that problem. And I think that's interesting. I think it's interesting in part because there is there would have seemed to have been a real market opportunity for someone to sell truly trustless ICO issuances. It's also interesting because it suggests to me that more of this is fraud than you might have otherwise hoped, that the folks don't want to be locked down to the promises that they've made. And it's also interesting because, at least sort of as a matter of economic theory, what you have here is a lemons market where lots of the stuff's bad. Not all of it's bad, but lots of the stuff's bad. Firms should be trying to seek to distinguish themselves on the basis of quality. They don't have that many obvious ways to do that in the area where the regulators have stepped back, so they haven't found a safe harbor that necessarily works. And so it's odd to me that in sort of a world that relies so heavily on technological solutions that they have not relied upon technological solutions, and that just makes me curious, I would say. I don't have an acronym for how it makes me curious, but it makes me curious. And I don't want to say like I think it's all bad, because I don't. I think there's a really interesting phenomenon here. I think it's a nice area of legal innovation, which is something I think lawyers are often blamed for not doing, that we don't innovate. Here there is actual innovation around a new form of possible property. But I think that I'm both skeptical and curious about what the relationship is between that new form of property and the underlying technology, which gives rise to the excitement in the field, does not seem to be tightly connected to the new form of property itself. So with that, I think I'll open the field to questions. So please be bold and be first.
I have a question. You previously mentioned, Josh, that the SEC actually does not have a test on how to determine, and they just blatantly say that probably most tokens are securities. And I was just curious what happened to the initial proposition that the Howey test is applied when determining whether the token is a security.
So I guess, again, this isn't legal advice, and it's not on behalf of the regulators, clearly, or on behalf of my law firm. I think the test still is the Howey test. I mean, that's what they said it is. However, the statements that have been made in terms of what is in the market right now, I think are chilling. Are chilling the token sellers and certainly the lawyers at big firms, right? So when you keep hearing, all of these are securities, all of these are sales of securities, it is difficult to take the risk, right? Especially when you have also Chairman Clayton saying gatekeepers, we're relying on you, gatekeepers being lawyers, also broker-dealers, others in the space, saying use your judgment. I think also it's not just the Howey test. So people focused on those various factors, but they forgot about the stuff that Munchie reminds us of, which is that the manner of sale is key as well. So you can have a token that on its face has characteristics that you say, this doesn't look like a security. I've structured it appropriately. But if I go to Professor Hoffman and Professor Rohrbach and I say, hey, this is going to go up in value, get in now, or something of that sort, then I may have taken this carefully crafted token that I have tried to, and I've gotten an analysis by a lawyer saying, what do you think? Although I will say, I'm not aware of big firms, I'm not aware of certain big firms giving legal opinions ever on this topic, although some certainly did. But, at least before it used to be an analysis memo, right? Kind of like an issue spotting memo. I mean, so much of this is like a law school exam, frankly. Where you look at this, I think now, given the way things are sold, and it's very challenging, because even if all the writing is, okay, fine, it looks less like a security, if you have a founder who goes on a panel and says, yeah, it's going to be listed on exchanges, and you'll be able to, then you've kind of undone everything that you were doing. So, yeah, that's...
I'm kind of interested in what enforcement or what regulatory ideas are around decentralized exchanges. So if you don't consider Ethereum to be a security, you could theoretically have a smart contract which transfers automatically between a token and Ethereum based on some decentralized exchange rate. And so are there any ideas on how to deal with that jurisdictional issue if you have this decentralized conversion?
Yeah, decentralized exchanges are the thing that always gets stated in terms of how this gets much harder. So the reality is very few of these decentralized exchanges are operating. There's a number of them where there's interesting work going on driving towards that. But right now, the predominant activity is on traditional kind of centralized exchanges. It clearly makes it a lot harder where there's no central actor operating these things. But I will say that at a broad brush level, the kind of problem is not all that dissimilar to the peer-to-peer problem that we dealt with copyright 20 years ago, which is to say, when you decentralize, you have no central agent that's controlling the exchange. It makes it harder to enforce, but it doesn't mean there is no actor that can ever be found to enforce against. And it's also true that, yes, if you want to create a decentralized exchange to do illegal drug transactions, where you're structuring everything that way, maybe you can run a little bit, but that's not going to get all the legitimate investors and regulated entities and the major source of funds to go into the system. So my sense is there will be a balance, and the decentralized exchange developers that want to be legitimate will have some reason to work with regulators to figure out how you avoid, again, the clear illegality and the clear regulatory arbitrage. I'm pretty confident that's ultimately how it works out. There's going to be things at the margin on the outside, but we're not yet even at that step. Right now, we're still just figuring out what happens if you trade this on Poloniex or Coinbase.
Yeah, if I could just jump in for a second on that. I mean, I definitely think things like decentralized exchanges are very difficult for regulators and regular people to kind of grasp even how they work in some cases, let alone how to enforce. But if you think about the DAO, which was, the first case, that was a decentralized autonomous organization. And one of the key things that the SEC said in there was, notwithstanding that it's a DAO, it's an issuer, right? So I have to imagine that the regulators could find a way. I don't know what it would be. I don't think technologically they have lined things up one-to-one, or that necessarily anyone has. But I think that one of their goals is to protect retail investors, and that's protect people who are not sophisticated. And so I think they have some flexibility in kind of determining how it's interpreted somewhat.
Professor Baker. So let's imagine that David Hoffman is 80% right, and 5 years from now, the fraud stuff is blown up and people are freaked out and very worried about it. What are the legitimate companies and entities going to do to prove, like how am I going to show that I'm a peach, not a lemon?
So, one thing is you're going to offer it as a security and comply with registration or an exception, which is already what's starting to happen. Another thing you're going to do is again, go through these regulated exchanges, kind of a flight to quality. And that's what, again, companies like, there are various ways that you can get various regulatory certifications, New York State bid license, broker-dealer, all these things. So some companies actually for a while, Circle is one of them, have said, no, we're going to go through all of these processes, no matter how hard it is, because we want that to be a signal to the market. I think there'll be more of that. And then I think we're going to see the growth of some kind of self-regulatory organizations. There's this idea that's sort of in the air in a lot of places, and the initial wave was, we'll just create something that's basically like a trade association that'll have some principles, and that doesn't really hold a lot of water. But now we're starting to see discussion about things that are of the scale of a FINRA, a true SRO that works with the regulators, it's got enforcement behind it, that provides some kind of check. It's not a substitute for the securities regulation, but some kind of check that you can go through some hoops that's validating in the market. So exactly how we're going to get from here to there is not so clear because there's lots of different ideas, and again, it's a multi-jurisdictional issue. But that seems to be increasingly what's being thought about.
I think also, in addition to that, the idea that you set up a team around you, right? And you have the right professional team. So these cottage industries have popped up in terms of people who will do your KYC AML, know your customer, anti-money laundering checks, your accredited investor checks, who will help you audit your smart contracts, who will help you write white papers. I'm working with an investment bank that's actually going to, I believe, be the first one to be marketing a security token sale. So I think we're going to see, if you think back to last year, one of the groups that was completely obviated from this was the traditional investment banks. And they were replaced sort of with these crypto investment banks. And now I think we're going to see them stepping back in. So I think as things get increasingly professionalized and as more eyes are on the white papers and doing an analysis of the team, et cetera, I think that'll help change the landscape because you'll have some that are in fact using professional teams and some that are not.
This is how all my students at Wharton are going to get jobs in this field.
Sure. So actually building on that point, I'm curious about security tokens and what your sense of the ecosystem is today and sort of it seems like there's a lot of demand for security tokens, so what explains the relatively slow movement? I'm curious about whether your sense is the SEC is prepared to read registration statements for security tokens and authorize the issuance of these tokens? And then also, do you think in 5 years, let's say, security tokens will become the dominant form of token being traded, and these so-called utility tokens, since they already are sort of being treated as they're already being treated as security tokens, we won't see any utility tokens anymore?
Sure. So I think we're going to see a couple of different trends. Number one, I do think some of the security token transactions, they're longer timeline things. Like if you want to do something on an S1 or you want to do Reg A+, you do have to have interaction with the SEC. I think we're seeing a lot of things done as private placements right now under Reg D, Reg S. One of the things that I think is important to remember too is that in a lot of these cases, the tokens have been pre-sold. but we actually haven't seen the token emerge at the end of the story. So if you're doing things under Reg D, for example, you could file a Form D at the end. That is beneficial to you, but it's not absolutely required in order to avail yourself of the exemption from registration. So there are token sales, or pre-sales rather, for securities tokens that are ongoing right now. We just might not be necessarily seeing them. For example, also the Coda coin, which was, I think, much publicized, right? The licensing partnership between Kodak and When Digital. When Digital, I believe, is actually the issuer of that, not Kodak. But that's being done under Reg D, and it's also partially under Reg S. I think partly, the ATSs for them aren't yet up and running. I understand that like Templum has launched, but it doesn't have anything on it yet, right? And same thing with T0, which eventually will have, I assume, tokens on it. I think that will, as that happens, you'll see more and more. I do think, though, that we will still have a place for utility tokens, particularly now that we have actual jurisdictions such as Switzerland, which clearly have gone forth and said, yes, there are these various categories. So it'll be interesting to see whether ultimately in the US there's some sort of guidance for what that may be, or whether this will just be a phenomenon that happens outside. I think also one thing that isn't focused on a lot, but I understand from folks in the space, is that a lot of these are being done actually as fork offerings, right? Where you fork an existing blockchain and then you end up having resulting tokens. So I think it'll be interesting to see how it develops.
No, you're next.
Okay. As I'm saying now, hi, thank you all for coming. I want to know from a privacy standpoint, what will be some of the key leverage points that regulators will look at to ensure that, one, data is being protected, yet still the degree of transparency so that regulators can go in and ensure that all is well?
Well, there's a couple dimensions to that. So I mean, just offering the token is different from the blockchain or the decentralized application that's behind it. And so we've been focusing just on the token itself, and where there's the issue of the disclosure requirements in terms of the issuance. It does relate to the fraud issue, because one of the big problems that's happened, in addition to just actual fraud, there's been all sorts of hacks and breaches where there's a token offering, there's $50 million worth of cryptocurrency sitting in a wallet account that was raised in the ICO, and someone goes and steals that. So it's not so much about privacy, it's about security. And that sort of gets into this larger movement that to the extent these transactions become more regulated, they sort of join the existing regulated environment, that leads to expectations that there be good security practices and good privacy practices. The larger issue about privacy around blockchain and cryptocurrency is a really interesting and challenging one, because on the one hand, these are potentially great for security, and they're potentially great for privacy because they provide lots more fine-grained control. You can maintain control over your personal data even when you give it up to a third party. But on the other hand, they're so new, and most of the rules that we have for privacy, either they don't apply in this context or they just apply domestically, and these things are global. So it's really, I would say, a whole different issue we're going to have to work through. It's probably going to come to a head around the European GDPR, the General Data Protection Regulation, which goes into effect in May, where it has all kinds of rules about privacy of data, many of which are actually somewhat hard to square with the way blockchain technology works, because once something is immutably recorded on the ledger, it gets hard to say, well, delete that information, for example. So I think it's not exactly the question you asked. I think that's where we're going to see, similarly to this hand-wringing we're seeing in terms of fitting cryptocurrencies into securities regulation, we're going to see similar kinds of challenges with trying to work through what it means with global privacy regulation.
And if I can, just for 1 second, on a token sale, one place where I think there are privacy concerns is, like I said, we have popped up this cottage industry of folks who will do your KYC AML.
Yeah.
But who's regulating them? And are they actually doing what they're supposed to with that data? Like, once you send it to them, what is happening there? So.
Thank you very much for sharing your thoughts and time with us today. Do either of you have any insights in what the state of Delaware is doing in this space right now and maybe an opinion on it or an update on the progress of what they're achieving and maybe the success or the failures that they're seeing?
So Delaware got out in front very early with a very bold and innovative idea. And the idea was the way that corporate share issuance is handled, if we actually look at the plumbing underneath it, is a mess. Because it goes through intermediaries, and you have situations where things get out of whack with who the record holders are and so forth. And so Delaware had this idea, we want to still be the place that corporations register, let's put it on a blockchain. And Caitlin Long, who was mentioned, who subsequently led the Wyoming work, was the president of Symbian, which was the platform vendor that worked with Delaware. And they got the technology built, they got the laws passed in Delaware to allow share distribution on a blockchain. Then there was a change in administration, a new governor, and the existing incumbent service providers, not the issuers, but things like the registered agents who make money by basically saying you've got to have someone in Delaware if you're a Delaware corporation, said, do you realize how much business the state could lose if you no longer need us? The whole argument was, why do you need a registered agent if you just put it on a blockchain? It's much more efficient. But they and others in the state who are these traditional intermediaries said, we provide a lot of jobs and a lot of tax revenue to the state of Delaware that might go away, and the state put the brakes on. So it's still in place, but it seems to have been slowed down.
So I have a little bit of an update that I can actually share this week, okay, so like I guess it's not out there yet, but it can be out there. I've been trying to, frankly, contact the press about it because I'm allowed to. So I'm part of this strategy group for Delaware now to figure out the way to implement it. And so we met, maybe like a month or a month and a half ago for a weekend for basically a day, over a weekend with some of the registered agents and with some people, about 15 of us. The Secretary of State and the Deputy Secretary of State, they engaged IBM to be a consultant to help us work through what the first phase and the additional phases might be in terms of how to implement. So what is anticipated is for the first rollout, there'll be a proof of concept, basically, or something a little bit beyond that, where it will involve UCC filings. As some of you may know, UCC filings are manual and they're kind of a mess. And if you're doing a transaction, they're incredibly important to get a security interest if you're a secured lender, which, as you know, is my favorite thing, other than blockchain. And there have been some really big, high-profile things, such as a GM bankruptcy case, which had the accidental release of security for a $1.5 billion loan. So the idea is, in this beginning program, just to start with, say, like special purpose vehicles that don't have a history already and start working towards that. Hopefully I'll be able to share more of this in a more organized way later. And then ultimately there are some other things with the stock ledger that would be like a later rollout, but it's going to be a phased rollout, and they do want to start moving on it. And I think there'll be more out about that very soon. But I finally this week can talk about it.
One more question, I think. Adam, I guess in the back.
So you mentioned the potential forks, but could you talk a little bit about how you think sort of the on-ramp might work for tokens and companies to be kind of brought into this securitized framework?
I'm not sure what you mean by on-ramps.
So, I mean, to bring all these companies that have issued tokens that right now are probably not within the securities regulation, and how, I mean, with the BIT license, I think most of the feedback was essentially that process didn't work that well, and how that might work better within the securities framework.
Well, so my guess is it's going to be there will be some enforcement actions. They will create something of a template. There will be some case-by-case mechanism, and there's a sorting process. Again, I suspect there are some of these things where they will bring the hammer down hard. They will require these things to actually be unwound. There's a lot of them where basically what's likely to happen is there's a fine, there's a consent decree. If you take the following steps to be compliant, then you can go forward. This is what happened, for example, with FinCEN, where they brought an enforcement action against Ripple. It's not about an ICO, but just about general know your customer anti-money laundering rules back in 2014. And they got through it, they were able to comply, and that was sort of the transition. A lot of cryptocurrency companies freaked out at that. They left the US and said, we can't possibly do this. In hindsight, essentially, it was a transition for some of these platforms to get to a more compliant position. So I think that's what's going to happen. I mean, you may have some more insider speculation about it in practical terms, but once you have some model that seems workable, then the companies can look to go to that model.
Yeah, I mean, so far the SEC and other regulators haven't really addressed what you do with the ones that already existed. Some people look at the DAO guidance and they say, well, that's kind of a warning, and maybe the people who came before, I guess we can't really do anything about that. And then some people with Munchie think, oh, well, that was another warning, because again, they just gave back the money. There was no real punishment except maybe some embarrassment, right? That you now are known for that. But I think, so it's unclear whether there will be some sort of like safe harbor or anything that eventually is developed. But I think the message from the regulators is we've given you some warnings and now comply.
And I can just add one thing before David wraps up. Just a reminder, if you don't know about it, the Penn Blockchain Conference is coming on April 6th. We may or may not be able to have room for additional student tickets, but check it out. We've got lots of really fantastic speakers. It's going to be held at Wharton in about 2 weeks, pennblockchain.com/conference.
With that, there's a reception right around the corner, and please Josh will be there, and almost Kevin's here a little bit. Thank you guys so much for coming and for being such a great audience, and thank you, of course, our speakers for being here today.